Bon, malheureusement, for the for the Lusophone, I won't be able to to translate what I just said. I hope that some of our Lusophone friends can understand a little bit of English. Just to apologize again that we were not able to secure interpreters. What we'll do, we are going to translate, the transcripts of this meeting, and probably send them to all of you in the next 1 or 2 days. Yeah. So over to you guys.
Thanks so much, Yusuf, for that. It's certainly helpful for us to know. And we were trying to secure, maybe Yusuf has not mentioned until the very last minute this afternoon, trying to see whether we could have someone, but that didn't work out. But thank you so much for the interest that you have shown in this process. This is like, we are piggy banking from the written submissions training that we did a couple of weeks ago. And this is not, it's a pretty straightforward kind of exercise that we intend to do today, just to share some thoughts and some ideas about how to go about the oral part of the competition, which for the most part is the substantive, or carries, in terms of a percentage, it carries a more percentage in terms of focus, in terms of intellectual output and input. And so Martin and I will go through the session and go through a couple of points. We have sent in the WhatsApp group the outline that we are using so that everybody is able to follow through on their own as we go through the training. We've scheduled it for 2 hours, but we could go through it maybe in an hour. We'll see how that goes. And then we can leave at the tail end of the process, opportunity for you to ask questions and, to share your reflections on what we've shared, and then happy to learn from one another as we go into the competition. So maybe Martin can introduce himself. Okay, my name is Sydney Tambasi. Sorry, I didn't introduce myself. Martin and I both did the Moot in 2021. I'm currently doing my LLM in international law at the Graduate Institute in Geneva. So Martin, please.
Okay, thank you, Sydney. My name is Martin Kioko Munyoto. I am happy to be here, and we look forward to taking you through some of the tips that will be important for the oral training session. As Sydney has mentioned, we did the Moot together in the 30th edition, and now I work as a lawyer at a law firm in Nairobi called Anjawala & Kano, and I look forward to an engaging session. Thank you.
Okay, thanks as well, Martin. I'm sure Yusuf is a familiar name, so he'll probably be in the background. But thank you so much, everybody. And yeah, so the first, really, like, we'll just go straight into the training. And the first point we thought to just highlight to the group is, this.
Sydney.
Yes, Yusuf.
Yeah, a quick one. I've seen that you shared that document.
Yes.
Just want to let, particularly maybe the Francophone and the Lusophone, they can quickly do like a Google Translate so that they have an idea about the points that will be, discussed. Alors pour les francophones, je crois que vous avez vu le document que Sydney a partagé. Alors, bon, disons pour pouvoir suivre ce qui se passe, vous pouvez peut-être utiliser comment dire, la traduction de Google. Comme ça pourra vous aider à suivre ce qu'ils vont discuter pendant cette réunion. Merci.
Thanks a lot, Yusuf. Okay, yeah. So yeah, based on that, I'll begin then on the first issue, which is what we call the essence of a moot competition and oral advocacy. What are we doing here? Which is, pretty much the question we are trying to answer. What are we doing here today? And it's important to note, I'm sure, for having read the question, having engaged with it, read cases and read articles on it, you understand that the question is a simulation of many of the issues that we actually face. And that's the whole essence of the competition, as I'm sure we all understand, that it's hypothetical in nature, but the vernacular of the competition is to try to articulate everyday issues that we face, and in this case, as a continent. The one thing I think that this moot court does, the Christof Heyns competition, is that it views itself as one of the instruments through which the African human rights system can be developed even further, even better. And there are many ways this is done at state level, through engagement of NGOs and so forth. But the competition itself as an institution provides this opportunity. And so what happens in this case is that you, as the competitor, when you come to the competition, then you have to understand your elevated value within this corpus of the African human rights system. That, you are not just there to, you are not lesser in terms of your value, in terms of your value addition to this process. And when you think of yourself as that, then that means that the kind of training, the kind of research you're doing, this is research that eventually informs the development of this process, because you would see, from the people who are there in the competition, for those who've been there before, it's usually the players within this African regional human rights system. And many of us ourselves in this room will eventually become that. So I think when you have this orientation, it really, really shapes and it elevates your position. And I think it takes away, this idea that there are going to be experts there and you are the non-expert and you're just going to learn. Other than learning, you're also going to contribute. So that's, I think it's an important baseline understanding for you to have as step closer and closer into the 0 day, as it were. I also think that generally what the competition offers is a complete educational tool, because you remember how the process is. You begin by doing your research, and then you write down your memorials, and then you have to edit it, probably a few rounds of editorial processes before you submit it. And then you have to write it. Actually, you have to do legal analysis, you have to do oral advocacy, you have to take feedback. This is the whole corpus of legal training, in this case in international human rights law. But many of the skills that are learned here can actually be transposed into other areas of career development, professional development, and educational enrichment. So this is also like one of the things I think why all of us would love to be part of this, or love to be part of moot court competitions, because the whole corpus of legal training, at least at undergraduate level, is presented to you within a fully fledged process like this, right? And the oral advocacy, as maybe some would ask, for instance, why is it necessary to do the oral advocacy part when we've already made our written submissions and presented them to the judges and they've been marked and all of that? And I think the answer, it's really, really elementary, but it's important to point out that a lot of the development of law, a lot of the articulation of social problems, economic problems that are done through litigation or through legal advocacy is done through the oratory part of this process. When you go to court and you've made your written submissions, this happens, I think, in all courts. I don't know whether there is any that does not require written submissions prior to making oral submissions. As much as the judges have read your written submissions, they've read your arguments substantively, and they can, as it were, based on that, they could make a determination. It's important for us then to step forward and say, add the human touch to it, add the emotion to it, add the emphasis to it. And these are some of the tools or some of the material we shall be trying to share with you. Then how do you bring your written submission into life? That's the essence of the MUTA, or the oral advocate, which is, part of why we are here today. And there are other things that are quite obvious, I think, at this point, like public speaking, critical thinking, because at every stage you have to answer questions from judges, you have to respond to issues that have been raised on the spot by maybe the counter, by the opposing counsel and all of that. And all these skills come together, they really make you as a young professional. So when you understand these things and you go into the process with this at the back of your mind, and to try to capture all of this together, then it becomes essential to I think it takes away the pressure, because a moot court competition, as I'm sure we know, has a lot of pressure. And sometimes you are not sure whether you are doing the right thing, you're not sure whether what you are doing is enough. But when you embrace it from an educational point of view, then you really are able to ease off some of the pressure and begin to absorb the learning points from the process. And I think the last point I'll mention before I hand over to Martin to... No. Okay, the last point I'll mention before I go to the second point, I'm also handling the second point, sorry, is that it's a starting process. It's, call it, like, for those of you who are fans of football, it's like the academy. The soccer academy, where you have young players who are coming through the academy, and a few years the line, they're the ones who are winning the Ballon d'Ors and all of that. It's almost a similar process. That through this process, then you are establishing your networks, you're establishing your love for the sport, as it were. And then through this, you enter into master's programs, and beyond that, you enter into the profession, whichever area of law you decide to choose. These kinds of experiences, many times when you talk to fully fledged professionals, and I'm sure some of them are here today, they would tell you how their mooting days, for those who did mooting, was essential in introducing them to to these issues at a very young stage, in a very exciting package style, like a moot court does. And from this on, then you're able to build on that. And I think this is foundational, basic, and I'm sure many of us know about this. But sometimes it's good to just lay down the foundations, then before we get into what we would call the substance or the essence of the assignment of the day. And that said, I would shift focus to the second major point that I wanted to talk about, or that we wanted to talk about, which is which is now more specific to the competition, the focus on the thematic areas for this year. It's a bit misleading, because what I will not do is I will not go into the specific details of the substance and tell you, specifically what to think about or what to research about, but it's more holistic in terms of the appreciation of what the competition is trying to do. So, for instance, this is something I'd already mentioned, that the competition is pushing the legal frontiers of legal development. In fact, there is an article done, or when we were doing the 30th edition, they were reflecting on the usefulness of the African human rights moot court competition. And one of the things that was coming up really strongly was that the simulation of the African court by the competition predated the establishment of the African court itself. So in a sense, before the court could actually sit, competitors had been doing this for quite a while, and they had created in the imagination of the human rights players and stakeholders within the continent that this is an institution that is possible. And essentially, that is what is happening these years, has been happening over the years, that you try to push the frontiers. And one of the points we shall be making is the importance of soft law instruments. I know that when we do preparation for moot court competitions, one of our main focus usually is the treaty law. What has the treaty said? The treaties. What are the treaties saying? What have courts said about the specific issues we are talking about? But one of the lesser utilized, generally speaking, in terms of moot court competition processes is usually the soft law instruments. And in the case of Africa, you have a lot of this within the mechanism of the African Commission on Human and People's Rights. Their special mechanisms generate quite a large body of soft law instruments that are particularly important. And you could go even to the Human Rights Committee if you wish, or you could even go to the International Law Commission if you wish, but you know that the preference of the competition is within the African human rights system. And when you understand this, again, it becomes really, it gives you the confidence to rely on these soft law instruments, which have not yet crystallized into hard law, as, say, ratified by being cited in case law, or by being articulated in hard law instruments. But then it's because of this that then you keep pushing the frontiers. You're saying, okay, so scholars have been talking about this for a long time. This is what the institutions that we've charged with developing international law on our behalf, on the behalf of states, have been saying for a long time. And therefore, maybe it is time for this to step out of the soft law instrument articulation into the hard law instrument articulation, for instance, beginning with being cited by a court like this. So take a lot of confidence and pay a lot of attention to many of the soft law instruments. Try to read at these last stages, try to read if there's any leading articles on some of the issues that have been written on, and the Center for Human Rights, produces a lot of scholarship on many areas of international human rights law. If you're able to read and understand the general issues under discussion, then it becomes really, really useful to you in the process. Now, one that I'll particularly mention is this relationship between the African Commission and the African Court. And if I'm not mistaken, you find that I think maybe only twice, I think under 3 times, we can cross-check that, or somebody can correct me in the chat if I'm wrong, that the African Commission has not particularly made use of this referral mechanism to the African Court. So now here you have in the competition where they are doing this, they are saying it's the African Commission bringing the case on behalf of the affected victims to the African Court. And so this is a relationship that you would want to think about. It's not directly asked in the issues for determination, but a judge would be curious, what is the relationship between these two institutions? Why hasn't this referral mechanism been used across these years, yet is clearly provided for within the instruments of the court? And so these are some of the questions you think about. The larger, I would call them the issues that are floating over the specific issues for determination that have been laid out before you. And so you want to look for literature on this. You want to look for anybody who's asked this question and tried to answer it through scholarship. One other thing I learned particularly important is, say, for instance, and this is quite recently, your demeanor when you're making the presentations. Again, this will come up as we continue to have this conversation. But you also just want to find out, if you're coming to the court as the African Commission, it's particularly different or fundamentally different from you coming to the court as an NGO or as an individual. In this case, you're coming to the court as a collaborator, as a commission that actually sits and makes decisions on international law questions. So that means that, for instance, one of the major assumptions on my side is, if I was sitting as a judge, if you are coming to me as the commission, then at the very least, you should know what the commission has said on any of the issues you are trying to articulate before the court. And this is also something I learned recently, called jurisprudential line. I didn't know about it as a concept, but I learned about it recently, where you are saying the commission has in 1, 2, 3, 4, 5, 6, 7 cases said or made the following determination. And this is why, the particular facts of this case are different, or this is why they are similar, and therefore this is why the court should take this direction or that other direction. So you see, these are things that unspoken, so to say, but it is, in a sense, it is assumed that you would know. And they're not like, they're not rocket science, as it were, because if you are, say, to key into ChatGPT issues on migrant issues, as the African Court on Human Rights or as the African Commission handled any cases on migrant issues, more likely than not, ChatGPT would give you the list. And then from then on, you can verify and see whether this is accurate and then build on that. But these assumptions, I think they are good to have at the back of your mind. And then one thing that I also found particularly interesting is the nature of the issues being articulated before the court this time round. A lot of the issues center on the rights of migrants. And if you've been following international development issues more recently, you would know that the world generally has moved to a lot of nationalism. So many of the articulation of, you would say, the most known world leaders or the most famous ones are speaking to nationalism, whether this is within the continent, you see that, whether this is in Europe, whether this is in America. And then here you have a moot question that is in a sense challenging these strong ideas of nationalism, because you have the group that is the complainant before the court, a group of migrants whose rights have been violated. Yeah, Yusuf, please, for sure.
Sydney, yeah, apologies. I'm trying to figure out whether maybe you're going to be talking about this because I think we're assuming that everyone here has mooted before, but it might not be the case. So I was wondering whether probably maybe you get to talk about from the moment they are called into the court. What happens? The preps between the team, how do they relate? What's going to happen? How do they address? There are probably some students who don't know how they are going to address the bench, kind of thing. So I was wondering whether maybe as a format so that they get to understand exactly what happens the moment they are called into the session, what's going to happen before you go into the very substantive, how they are going to deal with, the issues in the hypothetical case. Thanks.
Yes, thank you so much, Yusuf, for raising that. I think that was our fourth point: strategies for successful oral advocacy. So Martin will be coming this to handle that in a few minutes, and we shall actually break it down in terms of, as you say, from the beginning, the nitty-gritties. What are some of the specific things that you need to think about going into the process? Yeah, thank you. Yeah, so exactly. Like before I think we get into that, thanks Yusuf, it's to understand, what is the topography um, around which these issues have been articulated. And this is probably the last point I'll be making before Martin comes in. But it is for you to understand that, for instance, in terms of my own process, how I would do it is I would try to generally search on Google some of the issues that are coming through from the moot question. You just try to search whether these issues have appeared anywhere else. So has there any country had to deal with any of these specific issues? Because how moot questions are written sometimes, you would try to simulate and think, okay, this is an issue that happened maybe in country X, country Y. Can we try to make it hypothetical? And then from this point, then you begin the research like that, and it helps a lot in the competition. One of the best tools that I have seen is for you to tell the judges, for instance, that the issue before you is not a new issue. It is not unfamiliar to the African continent. We saw this happen in country X, and these are some of the measures that they utilized, and these are some of the measures we shall be borrowing, for instance, as a state, which is often on the receiving end in these cases. So I think generally, in terms of a summary of my introductory points, is just to understand that the moot is hypothetical, yes, but it is set within a certain context. A certain context that is very far from hypothetical. There are issues that have happened. There are people whose lives have been affected. On the other hand, there is a state that has had to make decisions, which in its case says it's making it for its own best interests. For instance, it could be national security, it could be public order, or whatever the reason it tries to articulate to justify these issues. And so when you try to understand where each party is coming from specifically and also within the larger context, then you are able to put yourself in that specific shoes and articulate it much better. Then allow me at this point to welcome Martin, who will talk about some points to think about in terms of specific preparation for the competition, as well as strategies for successful oral advocacy, which Yusuf pointed out a few minutes ago. Thank you.
Thank you, Sydney, for the very nice introduction. I think you've done well to set the stage for this part of our presentation, because the students now understand the importance of the competition and the thematic areas in which the moot is set, so that then when we come to talk about the practical ideas in preparation for the moot, then it makes sense in terms of the context. So before I get into the step-by-step preparation of you appearing in court, I think the first thing to talk about is your preparation just before you get into the courtroom. So we'll get into the courtroom. Before that, then we need to talk about how you prepare to get there. And the first obvious step, of course, is understanding the moot problem. I recall when Steve and I did this competition, we made the moot problem almost like our life. In fact, we would even tell stories in the names of the characters and the hypothetical characters in the moot problem. Why this is important is because you're probably going to be better read than the judges because you've interacted with the question many times. A judge in the oral round is likely to read the question once or twice, at most 3 times. But for you, because you have read the question, understood it, prepared written submissions on it, you're well placed to understand it better. So go through the facts. One of the ways to master the moot problem is by having like a timeline of sorts where you write it like history. So you understand, this happened, and then this happened, and then this happened, and then this happened, and that is why we are here. Understanding it in a very historical way is one of the ways you can do it. The other way to do it is by separating arguments. So having a summary of the moot problem where you identify what you consider to be the good facts for the applicants and bad facts for the applicant, and then good facts for the respondent and bad facts for the respondent. So for example, having something like, paragraph 1, 2, and 3 are neutral paragraphs, and then paragraph 4 is good for the applicant and bad for the respondent, something like that. So that then you're able to have a more in-depth understanding of the question. So you must tie the moot problem. Each of the paragraphs on record is important to the legal issues. So it is important to consider the hypothetical case in a wholesome way. So do not disregard certain paragraphs because you find them not to be favorable to your case on either side. It is useful for you to look at the moot problem in a holistic manner, and where you see that there's a paragraph or some wording that does not favor the side you're representing, then you must check and see whether you'll find, another fact or something else that can be interpreted to favor the side you're representing. So the question is usually balanced. I know sometimes there's a feeling that, maybe it favors one side or the other, but the question is fairly balanced. So an understanding of the facts will reveal this, and it will help you to argue the legal issues better. Once you have mastered the moot problem, the next step is then for you to structure your arguments. Structuring of arguments is actually very useful, and I find it as to be one of the most critical things in oral advocacy. Because when you argue in a very clear, logical way, then you actually end up to be more persuasive than someone who argues all over the place. You might know what you're saying, but it is useful to organize your thoughts. The truth is that everyone who comes to this competition knows the law. And they know the law, they have read the moot problem. At least there's a basic understanding of what's happening. What distinguishes you as a top oralist is your ability to structure your arguments in a way that can be followed easily, in a way that is logical, and therefore has the result of making you more persuasive. And for this, there's been prescribed a number of frameworks to use. The most common one, of course, is called IRAC or FIRAC or IFRAC, however you consider to organize it. But the idea of FIRAC or IRAC or IFRAC is that it has the following elements, which I will explain now in order so that you understand. The I, so let me also type it on the chat. So the I stands for issues. Yeah, so that's the framework. So the I stands for issue. So for example, in this competition, under paragraph 32 of the hypothetical case, you have the issues listed for you. So issue 1 is Baharia's adoption and implementation of the Election Amendment Act. Issue B relates to the deprivation of nationality. Issue C relates to the indigenous advancement policy, and issue D relates to the expulsion of the 400 Nkwafo to Zambezia. So these are the issues. So how you organize your arguments is this. When you are arguing, let us know where you are. Tell us that on the issue of jurisdiction, on the issue of admissibility, on issue A relating to the Electoral Amendment Act, on issue D relating to the expulsion of this 400 Nkwafo, the argument is this. So make an initial introductory statement for each of your arguments. So you're telling us that this is the issue and this is our position. So the respondent's position with respect to issue C is that, for example, there was no violation of international human rights law or African human rights law standards by these actions of the state. So that's the first thing. And that, I think, is very clear because it derives from the issues already listed in the hypothetical case. The second thing you could do then immediately after that is highlight the relevant facts, the facts that are relevant to that issue. So you could say, for example, that the facts in paragraph 12, 13, 14, and 16 reveal that these actions were undertaken by, say, the state. So it's just highlighting, you don't have to explain all the issues word for word. It's just highlighting what facts are relevant to your case on that issue. So you say, paragraph this, and this shows that this happened. If, for example, dealing with admissibility, you could say, according to paragraph this of the record, we see that the applicant appeared before the high court and the matter was dismissed, for example. And then according to paragraph 14, they subsequently went to the Supreme Court and the matter there was also dismissed. And therefore, there was an exhaustion of domestic remedies, something like that. So just point out the most relevant facts. Then once you've done that, you could go and state the law. So you're talking about the rules applicable. So you can explain that in making this argument, for example, the applicant places reliance on Article 2 of the African Charter as read together with, say, Article 2 of the ICCPR and Article 3 of the UDHR, which then provide for protection against discrimination, for example. So that structure helps you so that the court is following. One, you've told us what issue you're arguing. You've briefly highlighted the important facts for that issue. You've told us where you're getting the law. Then the next step, you go and tell us how that law has been interpreted or understood. So the A there could stand for analysis. And you're telling us here that according to the African court's decision in, say, Konate versus Burkina Faso, the position was that this and this and this is a violation, or this standard was prescribed. So once you analyze the interpretation of the law you have stated, also show us how it is relevant to the facts. So tell us, based on the interpretation in Victoire Umuhoza versus Rwanda, we see that this is a violation, or we see that this is not a violation, or in applying the standard that was set out in Mtekila versus Tanzania, the court should adopt a similar approach in understanding these issues before us, because this has happened before. In the case, for example, that it has not, the specific issue has not been addressed before the African Court or the African Commission, you could also invite the court to review jurisprudence from the European Court of Human Rights or the United Nations system. We have General Commons, we have the Human Rights Council, we have the Human Rights Committee, and we have all the other bodies, human rights bodies that produce jurisprudence and which the African Court can draw inspiration from. Once you have analyzed based on case law or jurisprudence or a scholarly article or a book, then proceed to tell the court what conclusion you would like the court to arrive at based on what you've told us. So that's how you go step by step. What is the issue? What are the relevant facts? What is the law? How has the law been analyzed, interpreted, or understood? And what conclusion should the court arrive at following from all these things that we have explained to the court? So this is how you need to organize or structure your arguments. It doesn't have to be in that exact format. You don't have to say, I'm moving now to the facts, I'm moving now to the analysis. No, you don't have to do it like that. Also, you could mention the issue and then go straight to the law. So you could say something, for example, you could say on the issue relating to the Electoral Amendment Act of 2013 and its incompatibility with the African Charter, the applicant's position is that this Electoral Amendment Act is incompatible with the African Charter. We rely on Article 4, 16, and 17 of the African Charter, to make this argument. So you could start there. So issue, and then mention what the hard law you're relying on. So I will now at this point talk about hard law and soft law so that we are clear on that before I go then to how you get into the courtroom and present these arguments. So when you're preparing for your authorities and for the explanation of the law, there's what we call hard law and there's soft law. So hard law is the black letter law that is contained in covenants, charters, treaties, conventions, or any documents that have been ratified by states. Of course, within the African human rights system, the most important one is the African Charter on Human and People's Rights, because it is the basis for which international human rights law is understood on the continent. However, we have other instruments that are relevant. We have the 9 core United Nations treaties, the ICCPR, the ICESCR, the Convention on the Elimination of Discrimination Against Women, on elimination of racial discrimination, the UN Convention on the Rights of the Child. There's 9 of them. There's also one actually on migrant workers and all these things that might be relevant. Then we also have the Universal Declaration of Human Rights, UDHR. It's also a hard law instrument you could rely on. So that is the starting point. And also the other charters within the African human rights system. So apart from the African Charter, we have the African Charter on the Rights and Welfare of the Child. We have the African the Maputo Protocol on the rights of women. And we have other charters like the Charter on Democracy and Elections. So look at these instruments as hard law. That they are the instruments which the state has ratified, signed, and said that this is binding to us. So that is the starting point. And then we have soft law. Now, soft law is usually an interpretation of these hard law instruments by treaty bodies. So, for example, within the UN human rights system, the 9 core UN treaties each have a committee or a treaty body that interprets them. And for example, for the ICCPR, we have the Human Rights Committee that reviews state reports, reviews shadow reports, makes concluding observations, and also produces general comments relating to specific articles of the treaties. Within the African system, of course, we have the African Commission, we have the African Court, we have the African Committee of Experts on the Rights and Welfare of the Child. These are treaty bodies that also produce jurisprudence in terms of case law, in terms of advisory opinions, and this is what we call soft law. It's an interpretation of the hard law that we've talked about. So this should also be used. So when you're using cases, again, don't just throw cases around. We hear a lot of cases sometimes from participants in the competition. It is useful for you to explain why the case is relevant. It is actually, in my view, better to use 2 or 3 cases in your arguments than to use 10 that are not relevant or you're just throwing around. So in each argument, 2 or 3 cases would be ideal because then you're trying to help the court understand in practical terms what you're arguing. And best practice for use of case law is that when you're mentioning case law, mention the parties. So say Jawara versus the Gambia. So, the applicant and the respondent. Then also mention the institution that decided that case. So, decided by the African Commission. Possibly tell us the year in 2000. So with that way, you also appear to be better read because you understand who the parties were, which institution decided the case, and when it was decided. Those of you who want to go above and beyond could also mention the specific paragraph in the judgment on which you place reliance to make your argument. So for example, you can say, we rely on paragraph 65 of the decision in Article 19 versus Eritrea by the African Court in 2007 or 2009. So that is also useful. Don't just say, in the Jawara case, in the Konate case, in the Mtikila case. I think it is useful for you to state the names of the parties, the institution that decided the case, where it was decided, and which year, and possibly tell us the paragraph. Also, regarding case law, when you rely on cases outside of the African human rights system, say, for example, you're relying on a case by the Inter-American Court, like Velasquez versus Honduras, decided by the Inter-American Court in 1987, it is useful for you to show why that is relevant. So don't just give us the case. Tell us why should we consider this case from the European Court, for example. It could be that the case has been used within the African system on a persuasive basis on a specific case, which you could highlight, or that it is, the locus classicus or the landmark case in that area. For example, when you think about, expulsion, deportation, immigration, you might find, some good cases from the European system or the Inter-American system, which then you would need to justify or qualify within the African system. So this is the part that relates to preparation of the competition just before you come in. Now I'm going to take you through the process of when you walk into the courtroom and how you make these arguments and bring them to life. So usually in the preliminary rounds of the competition, you will appear both as applicant and respondent. So you will appear both sides. So you could start as a respondent and then, go ahead as applicant or vice versa. So usually there's a bench of between 3 and 4 judges in each courtroom for the preliminary rounds. In some cases, you might have 2 judges, but that's rare. So usually 3 or 4. So you'll walk into a courtroom, the judges will be there, and then you will be seated on either side of each other. And the judges will introduce themselves and then ask you to introduce yourselves. So best practice is that one of the speakers, perhaps the one who's speaking first, could introduce the team. So for example, in the case that it's Sydney and I would say, my name is Martin Munyoto, appearing alongside my colleague, Sydney Tambasi, and we appear on behalf of the respondent, the state of Baharia, for example. And the second thing you must do is indicate to the court the allocation of time. So I would say, in terms of time allocation, I will spend the first, say, 15 minutes to argue the preliminary issues of jurisdiction and admissibility, as well as issue A and B. And then my colleague, Sydney, will spend, say, 12 minutes arguing issue C and D. And then we reserve, say, 3 minutes for rebuttals. So that's the first bit on introduction. I see we already have a question on dress code. So usually the court expects you to be in a suit. So it could be that you have a matching blazer and pants, and then a shirt and a tie. It is, advisable, especially for men, to always have a tie. For ladies, you do not necessarily have to have a tie. And then for the colors, I know as Africans, we have very colorful dresses. In fact, people here joke that my community has very colorful clothes. So for the court, I think it is important for you to consider, neutral colors, black, navy blue, gray, dark brown are the best colors for court, black, navy blue, or any shade of blue, really, gray, dark brown. Don't have very light ones, yeah? Avoid showing up in a red suit or a yellow suit, yeah, just as best practice. Then, for the shirt or blouse, could be white, blue, gray or black. That's okay. So again, you should avoid maybe wearing a very colorful shirt. For the ties as well, not very colorful or very floral. Don't overdo it. I think you get the point. We don't usually have gowns for the competition, except for the final rounds. So you do not need to, bring a gown with you, or the, what is it called? Not the hat. I forget what it's called now. Yeah, but you don't have to bring the gown or robes or anything. Just a suit, a simple suit would be ideal in the colors that we have prescribed. And then, so we were at the point where you have introduced yourselves. So the applicant team ideally will go first in introducing themselves, and then the respondent team. Do not mention the university you represent, and also do not mention the country from which you come. Again, just to avoid biases. So you will be allocated team code numbers, which you should use. So when you hear team 1, team 57, you know your team number. So do not introduce yourself using the name of your institution, just to avoid any biases. And then, so once you've done that, the applicant team will go first. And best practice, again, is to begin with the preliminary arguments. So jurisdiction and admissibility are the preliminary arguments. In my view, whether contentious or not, it is important to just make summary arguments on this. Even if you do not consider that, say, jurisdiction is contentious, it is useful for you to mention what position you take as the applicant on jurisdiction, because the court cannot assume that it has jurisdiction. As a participant, you must speak to the court about jurisdiction with authority. And then for admissibility, so on jurisdiction, I think you know that the court has 4 elements of jurisdiction. So again, it is useful to mention each of them and explain to the court whether or not it has these elements of jurisdiction. Then for admissibility, same thing. Whether you consider contentious or not, it is useful to make arguments on admissibility. And for this, Article 56 of the African Charter prescribes, I think, 6 or 7 requirements of admissibility. Because of time, you may not argue all of them. So it is useful for you to identify the ones that you consider to be most contentious. Again, usually it is the questions relating to exhaustion of domestic remedies, questions around reasonable time, and questions around whether these matters have been canvassed or determined before a court or a tribunal of competent jurisdiction. So once you have made these arguments, preliminary arguments on jurisdiction and admissibility, again, it is best practice to go issue by issue in that order. So it is best practice to do issue A, and then B, and then C, and then D. Again, this is best practice. However, you will not be penalized, and there is no problem if you decide, for example, that the first speaker, after going through the preliminary issues of jurisdiction and admissibility, would opt to do issue C and D, for example. You would not be penalized. That will be ideal. As long as you indicate to the court very clearly what issue you are canvassing, so that the court is not mid-argument surprised that you're arguing issue D while they expected you to be at issue A. So once you have, as a first speaker, concluded the preliminary arguments, please indicate specifically which one you're arguing. So you say, I'm arguing issue C or D. And then for each of the issues, again, you have the leeway. So you can do D and then C as a first speaker. And in that case, you must always be mindful of the structure I have prescribed, because if you adopt that structure, it will be easy for you to follow and for you to be followed. So that also if a judge stops you at the point of you making an argument on case law, you know the next point you're going to make, because you're organized like that. Now, general advice for this, please avoid making reference to notes. I know there's always a temptation for you to come there, with your memorials printed out page by page and you wanting to read your memorials. This is not advisable because the idea and the purpose of oral advocacy and the oral session is to test your presentation skills. Sydney likes to say it's like a dance. So you might know the lyrics, that is, the arguments, but then how you coordinate your feet is what we're looking at when we think about the dance. So then please consider avoiding to make a reference to your notes. You can have what we call heads of arguments, where you have, very brief pointers to each of your arguments. But please avoid reading your memorials before the court verbatim, or for the most part. The best idea will be for you to internalize the arguments, try to understand them, and try to structure them, so then you can just speak naturally. And the truth is, judges will notice when you're reading, and in most cases, you're likely to score less if you read through your arguments instead of just speaking naturally. Again, I appreciate that not all of us have mooted before. So this is a skill you learn over time. When Sydney and I started, again, it wasn't easy. We also, felt like we were not prepared, thought, we have to read, but it's something you gain with practice. So between now and the competition in about a week, it is important for you to practice as much as you can. Practice as much as you can together with and I think Sydney will talk about this in terms of teamwork, but yeah, that's the point. So now the other thing, because I see there's a question on time. Again, for first speaker, you must be very conscious of time. If, for example, you have allocated 15 minutes for the first speaker and say 14 for the second speaker, you must be conscious of time such that you do not speak for 20 minutes and eat into the time that your co-counsel should be using. So how the timing works is that there will be a court assistant or a bailiff in court who will indicate to you how many minutes you have remaining, usually in intervals of 10, 7, 5, 3, 2, and then 1. So again, as you practice, time yourself so that you see how much time you spend on each of the arguments. And that will also guide you to know where do you need to make summary arguments, where do you need to shorten your arguments so that you do not exceed time. So the court does not allow you more than 1 minute of additional time in most cases. You might be lucky to find a judge generous enough to give you 2 minutes, but 1 minute is standard. Therefore, please try to argue within your time. And for example, if you have 2 or 3 issues you're arguing, allocate your time between each of the issues. So you say, I intend to spend, say, 5 minutes on this, 4 minutes on this, and 3 minutes on this, for example. And then give yourself an allowance of 2 minutes for interruptions or questions from the bench and all that, so that then you do not speak for all 15 minutes, for example. Before I conclude on this, I think, so I think I've explained what a first speaker will do. Then when the second speaker comes in, the other thing you should avoid is a situation where the first speaker leaves an issue hanging or a question hanging and then leaves it to the second speaker. And Sini will talk about this when he talks about teamwork. But in the ideal situation, it is best for an oralist to conclude on their arguments. So then the second speaker comes in and is able to start on their arguments. Again, in the same structure. At the end of every argument, it is also useful to give a conclusion. So the court then knows what exactly you're arguing all through. And then once you are done, then you sit and you listen to the other team argue. And then at the end, as an applicant, for example, you have an opportunity for rebuttal. Now, regarding rebuttals, there's best practice, which dictates that you prepare rebuttals beforehand. By this point, as an applicant, you must have anticipated what plausible arguments a respondent can make. So instead of starting to scribble some rebuttals when the respondent is speaking, best practice will be that you have prepared rebuttals for the issues you consider to be most contentious. And then when the respondent is speaking, you could make an assessment and see which of the respondent's arguments is likely to be most harmful to you as an applicant, and probably opt to rebut on each of those. It is advisable to rebut on 2 to 3 points, not more than 3, ideally, because most times you reserve 2 minutes at most for rebuttals. So in that case, 2 or 3, at most 4 would be okay, but not more than 3 rebuttals, so that you also have very, very good rebuttals. So in your rebuttal, be crisp, very clear, and summarize. It's not the time to make arguments. It's the time to make very clear points. So if you have a rebuttal that you're preparing for, make it very, very clear what you're rebutting and what your position is. In this competition, there is no opportunity for respondents to say rebuttal. So, like the structure is that, we have the applicant speak for 30 minutes, and then the respondent speaks for 30 minutes, and then the applicant speaks for about 2 or 3 minutes, depending on how much time they allocated in terms of rebuttal. And then the moot ends there. So the respondent does not have an opportunity to say rebut, as is the case in some moot competition. So that's also important for you to know. And then at the end, judges will give comments. Usually they do not tell you the marks, they just give you comments, which will help you improve in your mooting, and that is how the session goes. So I hope that's clear. The last thing I would say here is, not to belabor the things I've said, is please master the moot problem, understand the facts, structure your arguments in a logical way. Do not read your memorials. Take time to prepare. Do mock-up sessions. Do mock sessions that are timed so that you know how much time you spend on each of the issues. Look at jurisprudence from the African human rights system and other systems as well. Most preferably for case law, use the most recent jurisprudence. If you quote before the court a case that was decided in 1970 something, and then your colleague or the opponent quotes a case decided this year, then you imagine that the case decided this year would be more persuasive. So much as we have the landmark cases, it is useful for you to try get the most recent jurisprudence, because it shows then you have an appreciation of more recent developments within the African human rights system. So that's the first part in terms of how you prepare for the moot. Now I'll talk about the second part, which relates to correct way of addressing the court is. What do you mean by correct way of addressing the court? I think you could just clarify that question and then I will respond to it. But if you mean judges, then the way to refer to judges here is Your Excellency. So judges before international courts or tribunals are referred to as Your Excellency, not Your Honor, not My Honor, not My Lady or Your Lady, So it is best to refer to judges as Your Excellency. Where is a judge president, you could refer to them as Judge President or Presiding Judge. It is also no harm referring to the judges by their names, as long as in best cases use a surname. So you could say Judge Tambasi, Judge Sayad, Judge Munyoto, Judge Mushiri, for example. So judges, you can refer to them as Your Excellency, Judge President, or Judge so-and-so, preferably using their surname. But I understand, sometimes we have very difficult or mouthful names. So you would be safe with Your Excellency and Judge President, Your Excellency, like that. So the second part relating to strategies for successful oral advocacy, I will try not to repeat the points I've already made, but this is away from the content and the preparation. It is more of what you do to be a strong oral advocate, especially in that moment. Because for oral advocacy, you are actually judged for those 10, 15 minutes that you're speaking. That is where your marks come from. So you've prepared, you have read case law, you have the most recent jurisprudence, you have understood the moot question, you have structured your arguments, you have prepared everything. how then do you deliver it in a stellar manner? The first thing is communicating effectively. And effective communication is a very wide topic. But generally, what you need to recall here is that you must try to have very clear and organized arguments. The starting point is actually pace. So, and accents, because we appreciate that this Moot is very diverse. We have teams from all corners of the continent. And therefore, our accents are different. You struggle with my accent as I struggle with yours. That is the nature of the African Moot, and it's part of our pride. So in order to reconcile these, one of the things you should consider to do as a speaker is to speak slowly. Of course, not very slowly, but slow enough that you can be understood. Because I know some of us have lighter tongues where you speak very fast and you speak as you breathe, as you think, and that can be an undoing. While you will not be penalized for it, you will naturally lose the audience in cases where you're not clear. So try as much as you can to be paced in how you're speaking. Like the way I'm speaking right now, I think will be an ideal way. So it's not too slow, but it's not too fast. Because again, we have different accents. The organization I talked about also is very useful in this. Because the moment you have a structure in your arguments, you're easier to follow, despite our challenging accents. The other thing is to use persuasive language. So persuasive language is authoritative language. Understand that every word or phrase that you use can be used against you. So be careful how you make your points. Do not use derogatory or abusive language. Do not be condescending in your language or be mean to the opposing counsel. So for example, don't appear as a respondent and say, the applicant has made useless arguments before this court and wasted our time. No, do not make such arguments. Or as an applicant, not come and say, the respondent, they're just heartless. They've been killing people and, So the kind of language you use must be diplomatic, must be respectful, because we are all arguing. It's just a hypothetical case, yeah? It's not a fight. So be careful not to use language that could be demeaning or condescending to the other party. Then your tonal variation, you realize even when I speak, the times I speak in high pitch, in low pitch, the times I emphasize a point, and there's times I am not speaking in emphasis. Again, this is a stylistic feature, but it is useful for you as an oral speaker to practice modulating your voice and varying your tone so that you put emphasis where it's necessary and you speak, without emphasis where it's not necessary to speak with emphasis. So these are soft skills that you learn with practice. But as I say, please practice, practice, practice. The competition wants you to come prepared so that you shine. So practice before a mirror, before your teammate, so that you are able to deliver this very well. Now, the other thing is to remember that the judges are human beings. So don't be too rigid. There's people who come there, they are so rigid, they are afraid, they have a stone face, no smile, no, One of the ways you actually do well in oral advocacy is by being warm towards the bench. So where there's an opportunity for humor, take it, make a joke. Of course, you must be measured in that, but where there's an opportunity to humor the judges, do so. Where there's an opportunity to tell a story, do so. Of course, with moderation. But the idea is that you don't come to the court rigid and looking, very serious and unable to captivate the bench, because Sydney likes to say that this is a dance, as I told you. So how do you coordinate your steps? How do you, make yourself captivating, interesting to the judges? Don't be, of course, too dramatic, But that balance is useful. So you're not too rigid, but not too dramatic. Because again, the court must be honored. So you cannot come and start to make a circus out of it. But it is useful then to try as much as you can to captivate the bench, keep them attentive, with like to go with you through the arguments. And then the other thing I will mention is response to questions and court etiquette before I allow my colleague Sydney then to conclude on teamwork and team dynamics that will help to collaborate. So in terms of questions, I'm usually very deliberate about the fact that questions are very important. Do not see questions as a waste of time or as judges being problematic. In fact, you should be worried if judges do not ask you questions, because it could be that they don't understand your arguments or that your arguments do not make sense. But then you should also be worried if judges are asking the same question in different words a number of times. So this is the thing with questions. By now, you have had, I would assume you've had a number of practice sessions with your teammate, with your faculty coach, or with former mooters from your school, or just between yourselves. And that during these sessions, there are certain questions that have arisen consistently. My best advice, even before you get to the competition, is for you to have a list of what we call frequently asked questions. Questions that have arisen even through your practice rounds. Because you will not get very many new questions. As Sydney has, for example, hinted to you, the court will ask you, why is the African Commission appearing before the court? The court will ask you, has the commission ever appeared before the court? How many times? What was the outcome? So there are certain questions that you should expect when you argue that, for example, there was deportation or there was expulsion of people. They will ask you, when did it happen? Was there an order? So there will be questions relating both to the facts, but also to the law. When you argue, for example, that this article of the African Charter protects against, provides for the right to nationality, you will be asked about it, for example. So first step is prepare a list of frequently asked questions and have answers for them. So do not wait to be shocked and come up with an answer before the court. No. If you know this question will come up, prepare for it already. So read a bit more, possibly have an answer, a draft answer. You don't have to cram the answer, but if I'm asked this, I will respond, using these words, or I'll say something close to this. So that's the first step, which is before the competition. Now, within the competition, when a judge asks you a question, it is important for you to listen carefully to the question. Possibly, if you can, note it down. So you listen and say, Judge Tambasi is asking me about, the Electoral Amendment Act and how it affects nationality, for example. So you take note of the question. Where a question is unclear, because sometimes judges, could ask very long, convoluted questions. If a question is unclear for whatever reason, whether it's long, convoluted, or also because the accent, or maybe the judge was speaking in a very low tone, you didn't get it, you could request a judge to rephrase or repeat the question. No one takes offense. So if the question is not clear, please request the judge to rephrase. But again, don't do it too many times, because then judges realize that you're just, doing it like that. But yeah, ask. So where the question then is clear, be sure to understand what question you've been asked. If you don't want to ask them to rephrase, you could ask them, does Your Excellency ask the question relating to this? You could, in a sense, clarify it. Just ask them, did I understand Your Excellency's question to be about this and this and this? And then they will say, yes, go ahead. Okay, so that's the first step. That you listen to the question and make sure that you've heard it clearly. Now, when you respond to a question, please respond directly. I know judges sometimes can corner you into a yes or no question, or into a question that requires you to pick a position. my advice would be that you try as much as you can to respond to questions directly. So for example, if you asked maybe a question relating to the indigenous advancement policy, and the judge asks you, does this policy discriminate against children? Or, by providing for this, does it violate the right to education, for example? You could respond that the right does not, the policy does not, or the policy, yes, the policy does violate or does not violate, and then explain. So please respond to questions directly and then explain. Best practice would be also that you give your response with authority. So you could even give a case law or make reference to hard law or an instrument in responding to your question. And then lastly, I will talk about court etiquette and professionalism, which I think I have already addressed, but I think it's just important to just point out a few things. So regarding dress code, I have told you what to do. Regarding addressing the bench, I have mentioned how to refer to them. And also regarding your opponents, please refer to them as, the applicant or the respondent, not the other side, or these guys, or, the lady, the first lady who spoke, or the guy who has just spoken, or the tall girl, the black guy, just, it's etiquette. So you could say, the first counsel for the applicant argued that, the respondent has stated that. However, we disagree and state as follows. So how you refer to your opponent. Then questions from the judges, be clear, be simple in your responses, and please respond to all questions. Sometimes you could also get a situation where 3 judges are asking questions at the same time. So you have a question from this one, and this one. Take note of them and reply to all the judges. I say it a lot of times that judges take questions personally, because that's probably what I came to hear. So if you don't respond to my question, then what's the point of you arguing before me? So that's the last thing I will say. And then invite my colleague Sydney to talk about teamwork. Keep your questions flowing on the chat box. And then we'll also have a Q&A question at the end. But if you have a question, please feel free to type it on the chat as you've been doing. Welcome, Sydney.
Thanks a lot, Martin. Yeah, thanks a lot for that. I think that was really, really elaborate in terms of the step-by-step procedure of, of the process of it all. So my advice would be, Martin has gone through it like, in a very, very systematic way. And maybe what you might want to do is to just go on YouTube and look for 1 or 2 or 3 moot court videos. The center posts most of them online, whether it's from last year or the previous year, and just to try to contextualize what Martin has said and see whether you can identify these things, whether it's etiquette, whether it's introduction, whether it's response to questions, any of the things within the corpus of which Martin has mentioned. And then this will really, really help you to put them into context, and then you can try to emulate. A lot of mooting is espionage. You just try to emulate what this other guy said, not what this other guy is wonders against that, what this team said. And so you try to, to articulate it like that. I think that would be really, really helpful in terms of just knowing the actual application of what happens. And the reason why I advise this is because, and maybe I'll just mention something about the dance, and maybe in less than 10 minutes I'll talk about teamwork. It's because all of these things you are required to articulate all of them, to understand all of them, to argue well, to manage time, to respond to questions, to respond to the opposing team, to be kind to whoever. And all of this is happening in under 15 minutes. So it's really, really useful actually, to see how all of this can be packaged into this very seemingly short duration of time. And lastly, just on the dance, which is, before I go into teamwork, remember that your primary obligation when you stand is you have your arguments prepared, whether you are the first counsel for the applicant or second counsel for the respondent. Whichever counsel you are for whichever side, you have arguments that you have prepared. So you're expected to give the arguments primarily. yet at the same time to respond to all the questions that are coming from the bench. Now, if you are a respondent, you are expected to give your arguments, respond to the questions from the bench, and respond to the arguments made by the applicants. So you see how this task is. It's like, in a sense, the Moot expects you to be a magician of sorts. So the good thing, when you are aware, you have a good awareness of your argument, you have a good awareness, you've been paying attention to, say, if you are a respondent, you've been paying attention to what the applicants have been arguing, then you are able to sort of integrate their issues into whatever you are going to argue, because we are usually arguing around the same issue, the same issues. And then when the judges ask you a question, a common mistake maybe is usually to answer the judge's questions and then finish and then now go back to where you had stopped. But if you can find a way to integrate the judge's question into, maybe if it feeds into something you are going to talk about, you might want to speak about that as well, because time is going, and the idea is that when the judge asks a question, the time is not stopped for you to answer the question and then go back to what you're arguing. So these are some of the nuances in terms of time management, and the videos that the links that Martin has been sharing can be really, really helpful to just see practically how does this actually happen, so that you're not overwhelmed by how we are theoretically explaining it here. Now, moving to teamwork, I think this is probably my favorite word in the Mooting dictionary, because, yes, Yusuf?
Thanks, guys. I just want to quickly, and because I think we talked about, etiquette, demeanor and what, and I want you also maybe to touch on, how to, temper and to handle the pressure, because I've seen, and I think it has happened. I can't remember whether it was last year, where I think one of the oralists even stormed out. So I think, and also, even though you this is a hypothetical thing, they have to understand that here they are arguing. I mean, they're in a court.
Yeah.
Imagine you are in Arusha before the African court, and then suddenly storm out. I mean, you're there to represent, your client. Now what? You get a little bit offended because, the judges, suddenly now what? You storm out. So that's, I think you need to talk about, because I think Martin, touched to it. At some point, you've got, different style, how, the judges, evaluate, you've got judges who want to hear your arguments substantially, then probably, reserve the question a little bit later. Others who want to see they want to test how you think quickly, on your feet. And I've seen a lot of, some of these, young students losing the temper and completely even forget, because you're going to see how, I think Martin talked about it, where a judge interrupts you, asks you a question. Before you could respond, the other judge comes in, the entire bench now finally, comes in. Now it's, I don't know, for questions. Now, suddenly, of course, as you're trying even to figure out, which question to answer first and what, then eventually do that, then you forget, you ask them, then you want to go back to your thing, then you start losing your temper. Now you become a little bit belligerent. Now you want, so I think maybe, try to talk about how you handle pressure, and how you can even tactfully, in a way, without necessarily, let me say, okay, hypothetically speaking, let me say, Martin, maybe this is something you should address. Let me say you ask a question, and you don't know the answer, or you don't have the answer ready. How there could be a tactic, how in a way you can probably, move around a little bit, because some judge might say, look, you're not going to move on until you answer my question. I ask you a question, I need, thing. I think maybe you need to handle those things, because I've seen, orally scramble, they lose their temper. Eventually it becomes a little bit of, so that's why maybe a little bit of tactics to offer, how to handle that kind of situation, and how to keep your temper, kind of, yeah.
Thanks a lot, Yusuf. I don't know whether, Martin, I can have a first go, and then you can come in, and then we can go to the teamwork bit. Yeah, I mean, thank you so much. I think this is incredibly useful, Yusuf, that you raise it, because as you've said, you've seen it happen, and there's always a potential for it happening. Maybe I'd say, like, I have 3 points when you are talking, I was trying to put down, that I think would be useful to address these kinds of situations. So the first one, which I think is incredibly important, is the mindset within which you adopt as you're making the arguments. And Yusuf has already hinted to it. It's hypothetical, but you are in a court. So there is a sense of seriousness that is associated with the exercise that everybody within the room is expected to have. So for instance, things like etiquette and all of that, are you courteous to everybody? And even the judges are expected to be courteous to you. Now, one of the, in terms of a mindset, one of the most useful ones that I ever read was that when you're in court or when you're making the arguments as a mooter, when the questions come from the judges, try to think about it like this, that this judge genuinely does not understand what is happening, and therefore it is my obligation for me to try to explain to them. Now, already this, from a mental point of view, it gives you an upper hand. Now, the opposite of that would be if a judge is very harsh on you. So, Chidera or, Dukas, tell us this and this and this. And you think, oh my God, this judge knows the answer and knows everything, and I don't know. And so it puts you at a lower position. And that means you are easily likely to fumble, to lose your temper, and to scramble around and, just make a mess of the whole situation. But if you already put it in your mind and say, okay, it doesn't matter the tone, it doesn't matter how many questions are asked, the judges genuinely just want to understand what is happening. Whether it is factual, are you sure that the Nkwafos, were on this date? Are you sure that is the position of the court in this, It doesn't matter the structure of the question. Just try to think of it like, I need to explain to them, and this is my opportunity to actually shine. It's like they've given you a penalty kick in football, and your obligation is only to score it. And this helps a lot. Now, the second thing, I think the judges usually are briefed. So you shouldn't now go being afraid that the judges are going to come at you with crazy questions that you don't have answers to. They are briefed and we talk and all of that, and they know, the kinds of questions to ask. And so largely you wouldn't be in a position where you are cornered illegitimately. Most of the time when you are cornered is because maybe you are not clear, the things Martin has talked about, you are not clear, maybe you didn't address something well, or you've ignored something, and so forth. And so then the point is to move from this point of clarity or this point of having left something out to actually introduce it. And one of the experiences, practically speaking, that we had was, I don't know whether this was during the quarters or something, and there was this judge who was on our case. He was asking very hard questions. You answer the same thing Yusuf is saying, you try to navigate, they're like, no, 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 go back to that point. And, it was so hectic. But then, and again, Martin has already mentioned this, if you maintain warmth, just try to smile. Uh, Pardon me, Your Excellency, as I have explained before, or the position based on our research as a team is this, or Your Excellency, truthfully speaking, that question was a very difficult one when we were doing the research, and maybe we shall just try to explain to you, how we came up. There's a way in which you try to be diplomatic, you try to be warm, you try to be nice. So what happened in our case, we thought the judge had really killed us. When we actually took the score sheet, he was the highest scoring judge in that round, and the highest marks from that judge. And so sometimes, when you are sitting as an oralist, you're like, oh my God, I think this judge wants to fail me. All these hard questions, they're going to fail me. But if you understand that is not the case, then you don't throw in the towel before the game is over. Yeah, so humor, warmth helps a lot. Try to listen to what the judge is saying, and I'll speak to this briefly in teamwork. When you see your teammate is in trouble, try to nod, try to smile. You see them giving an answer the way Martin is doing. Just nod, not vigorously in a way that is creating a lot of weirdness in the court, but just nods politely, look at them, try to show some support. And this really helps through this difficult position. Maybe Martin, you can come in and then we can talk about teamwork a bit.
No, Sydney, you've nailed it. I have nothing to add really. You can just proceed to the teamwork points. I think you've done well to explain how to handle those questions under pressure.
Okay, thank you so much. So I think I'll then begin on that with respect to teamwork. That we like to say this, that it's something that is beyond you, beyond the individual, but within the duo. And and it's your obligation as a team member to really take care of your teammate. And now, if me and you are teammates, I take care of you, you take care of me, the loop is complete. That means we are all taking care of each other. And what happens is you eliminate every unnecessary kind of disagreement, conflict, and all of that. And you only deal with the ones that are actually legitimate. So in my opinion, I think teamwork really makes or breaks your experience in the competition. And we've had these kinds of experience. Yusuf has mentioned one about somebody running out of the court. We've had an experience where people come on the same flight and now suddenly they're not talking to each other. And this is just normal conflict management. A moot court is a very high pressure environment, as we've already explained. Sometimes hard questions from the bench. Sometimes, you are trying to implement a strategy, it's not working, and you have to re-strategize and all of that. And when you think of it as any human relation, as a preliminary approach to it is, we are here trying to achieve this goal together. We are going to disagree certainly on a number of things, but the idea is, can we try to be the bigger person, understand each other's perspectives? Maybe my teammate has made a mistake. Martin has made a mistake. We already told they are going to ask us, why is the African Commission bringing this case? And you researched and you had the answer. And then he was asked and he just said his own things. You need to be able to forgive them as quickly as possible, because these things happen. It's human relations. Forgive them as quickly as possible, because what happens is, if, say for instance, I don't know, say for instance, Robert is my teammate. He's the first applicant. And he goes and he had agreed to speak for 14 minutes. He speaks for 18 minutes, and somehow, it's unlikely, but somehow the judges allow him to speak for 18 minutes. Now I'm starting to panic as a second applicant, because now he's eating into my time. I'm starting to feel annoyed. We agreed during the training that you should speak for 14 minutes. But if you allow that to really get to you, then what happens is that when you stand to speak, then already you've lost the warmth. When you are trying to smile, you're already angry, you're already annoyed, you're already moving at a disadvantage. But when you understand, hey, okay, look, these things happen, it's fine. Maybe I have 4 minutes less. Let me try to structure my argument to fit within this time. And then you adopt the structure of warmth. Then this really helps to avoid the really nasty situations. Another key point is just to be aware of what your teammate is arguing. So, and this is particularly important for the second respondent. Or for the second oralist, right? Whether you are an applicant or a respondent, so that you don't stand up and actively contradict what the first applicant has said. And even I think for the first oralist, it's particularly important, because if you do not know the arguments that the second oralist is going to make, and you stand up and you start to make points that are contradicting what they are going to say, already they start to panic, because it's like, I'm going to say the exact opposite. What if they ask me the questions? What if this happens? And this doesn't speak well to the team. And remember, at the end of the day, the overall performance is based on the score of both oralists. So listen. And many times I used to be the second oralist, and I used to get caught in this trap many times, that when the first speaker is speaking, I'm there preparing, trying to structure, how will I answer this, how will I do this, how will I do this? And more I learned, okay, try to do this before the session, and then during the session, that just listen to what they are saying. Now, this could be particularly important, because when you look at the score sheet, there's a mark for teamwork. So for instance, if my teammate has been asked a question and I'm coming as the second oralist, right? And they answered it somehow, maybe I observed and I saw maybe the judges were not convinced, and I'm able to just somehow integrate this into an answer I will give, or one of the points that I will be making, and try to flesh out that issue, or try to say, as my teammate mentioned, this is the position. You see, the judges already can, especially the judge who asked that particular question, they can quickly pick up, okay, there's some very good teamwork going on, and you get an additional 1 or 2 or 3 marks. And this is usually super helpful. Now, as a first oralist, if there is a question that is asked to you and does not specifically touch on your arguments, but has something on what the second oralist is saying, you could just respond to it briefly. The thing we were doing here, I will say this, and then Martin will come and talk about this. And then the obligation on Martin is to make sure whatever you promise the judge, deliver. If your teammate said you'll come and address this, try to make it to address it. And you can earn an additional point by saying, my teammate deferred this question to me, or deferred this point to me. I would like to respond to you, Justice Sayad. And you know, already Justice Sayadu asked the question, who raised the point, is like, okay, I'm important here. You know, they recognize my question. And so you already win favor with the bench. So these are just some of the nuances. Another thing maybe is, you know, and Martin already mentioned again, is to practice together. Try to practice together, try to spend time together. When you go into the competition, if you know, if there's some opportunity to, I don't know, visit a place or to just walk around the university or town or wherever, try to do this together. It really, really helps with the teamwork. Because it's really, really hard to articulate chemistry within a team. But I think one of the most successful formulas is to just try to spend time together. Now, when you spend time together, you would know what annoys my teammate, what makes them happy, you know, what makes them angry, you know, what issues are they going through at home, because, you know, we are human beings and we have all of these things happening together. Maybe there was some money that was to come from an uncle for South Africa, it's not come. They're angry, but now you're like, you know, money will come, colleagues, money will come. You know, it's just these kinds of things when you're teammates and you try to feed into each other. Yeah. So now when you spend time together, for instance, I would know, hey, Martin doesn't like when I say these things. So because of my emotional intelligence, I'm aware of that by virtue of having spent time with him, then I try not to bring those issues. And you know, these things usually come up when there's a heated argument. You know, it's like, you know, we are arguing over an issue and then I attack him on something that he's particularly sensitive about. For instance, I say you don't have beards. You know, on my side, maybe it's just something small, but for him, it's very sensitive. So these are things you just understand by spending time together, yeah? And they might sound like funny and Martin is laughing, but trust me, we had some really, really, and I'm sure like working to, even in group works when you are doing assignments, and you know, somebody was to send an assignment on Sunday, it's Tuesday, they haven't sent anything. Oh my God, you know how these things like can get really, really tough. So I'd say try to understand it like that. And try to be gracious. For most teams, I know usually come with a faculty representative. I don't think this is the case for 100% of the teams. And usually a faculty representative is very, very important because they are there with you. They're able to help you, you know, solve problems that are arising in the moment. And you know, you're able to handle them together and all of that. But even when there is no faculty representative, you know, uh, the dynamic, you know, you being a duo, you working together for something that is larger than yourself, for an experience that will outlive each of your individual experiences, really, really helps this. So you are trying to be the bigger person. You know, if you are annoyed, you are trying to be the bigger person. And I said earlier, if all of you are trying to be the bigger person, then the net effect of this is that, you know, both of you are the bigger person, and that means that you are not caught up in, you know, the very petty minute things. I don't know, you know, somebody was to come with an iron box, they forgot it at home, or you requested him to carry your shoes and maybe he left them on the seat, you know. And these things, they're like small, but they really, really speak to your demeanor, right, in terms of your attitude and, you know, your happiness and your joy, and you are just, you know, being happy to be in Cape Town, which is a really, really beautiful place. I've only been there once, so for those who haven't been there, like, it's really amazing, and you really, really have to enjoy the thing, enjoy the experience, and let this thing not be a traumatic, you know, one of those traumatic experiences. I'll maybe mention just 2 or 3 more points that I think are important for teamwork, and this is like listening to each other with intent. Yes, Yusuf, please go ahead.
Just to add, I think you were talking about high pressure environment. I think maybe I imagine here probably I've got most of them haven't like mooted in that particular, etc. You know, the school moots and kind of thing. Maybe they need to understand how, because you argue 4 times. You know, so it's first day on a Tuesday, it's twice before lunch, then twice again after lunch. By the way, it might even depend ultimately on the number of teams we're going to have and the number of judges. We've been, contemplating a situation where we could have 6 sessions, 3 before lunch, 3 after lunch. And that, to tell them, they have to understand that in between, if you don't have that chemistry, that kind of thing, between the team, between finishing, one session going to another one, you probably sometimes you have a couple of minutes. Probably no time maybe to grab, drink some water, eat, a sweet or whatever, and go through your notes because now you just finished as an applicant. Now, second round, you're going to be, and they have to understand it doesn't always follow that way because, second round could be probably the opposing side. That kind of thing. Then it's just a little bit of time to be able now, forget about what happened in session one and to quickly, just now, shift your mind, go into completely because now starting second session, you're going to argue as a respondent, assuming that you started as an applicant, and you have a couple of minutes in between to be able, to. So that's why, I wanted to say, they have to understand when you talk about, high pressure environment. It's literally, that you don't have time. But at the end of the first day, you're completely exhausted, physically and mentally. Now you have to think about the following day. The following day, it's the same thing again. It's 4 times, twice each side. And that's, the other thing, of course, even though you're going, of course, the schedule is going to be released. You will know exactly in what order, but the point is that you don't really have much time in between to be able to switch mentally from one side to the other. And so that's why, I think what Sydney was talking about as, teamwork and understanding each other and be able to manage, this kind of sometimes, useless, conflicts and focus, what is at hand. Yeah, thanks.
Yeah, thanks a lot, Yusuf, for putting that into perspective. I think he really paints the picture in terms of what we mean by high pressure environment. And maybe in relation to his point, which is, I think both of us have mentioned this, disputes will happen. You'll disagree over something, maybe somebody underperformed, maybe, whatever it could be, disputes happen. But if you can find a way to handle disputes very well, and he said, it could be you just have a few minutes and maybe you are trying to grab something, maybe you are arguing as an applicant and now you're going as a respondent and you're trying to read your notes. But if you're able to forgive each other quickly, just forgive each other in fact, forgive each other very quickly, but also forgive yourself quickly. Because you could be like, I had the answer to that question. But now you're already over focusing on the answer you had to that question instead of moving on to the next point. Now, if as a teammate, I see that my teammate is like, this, like, hey, they have another chance, things will go well. So this is the kind of dynamic we are talking about. Just be aware, try to understand. And when both of you are aware and trying to understand each other, then you're able to notice some of those things. So at no point should your teammate be struggling alone. You should be able to pick this up quickly and try to help, try to involve the faculty representative if they're there. If they're not there, then try to solve it among yourselves. Maybe the last 2 or so points, and then I'll hand over to Martin, is, listening to each other with intent. So usually this happens when you have a dynamic, whereas it was in our case, where you have maybe one member is in second year, another one is in first year, or maybe one member is in a class ahead of another, fourth year, third year, second year, it could be. And what happens usually practically in these situations is that the younger team member usually waits on the guidance of the elder team member. It happens naturally. We're always looking to the elders for some direction and some support. But the flip side is that the elder team member could at some point be dismissing the younger team member because I know more, I'm the elder here, I know more. And it's happened, and there are many stories to this, but I won't go into that. I'll just say, as an elder team member, whether you're in third year and your team member is in second year or whichever the dynamic, try to listen to them. Show that you actually care about their research. Share that you actually care about their concerns. If they're saying, look, they asked you this question, I think I had come across it in this case, say, okay, let's go, let's check and find out. And this involves them in the competition. And when they feel involved, they feel important and they feel like they want to contribute. But if you are dismissing them, then they shy away. Even maybe there's something that could have helped the team as a whole, but they're like, I don't know much, I don't want to help and all of that, right? As a younger team member, even as you look to the older team or the elder team member, I'll just use elder for direction, you have your own independence. You've done your research, you have your issues that have been allocated to you within the team dynamic. Trust your research. Don't be shy to say that, everything, you just listen to what the elder team member is saying, right? So try to maintain your independence, try to maintain your confidence. And these things, they're important, as you spend more time together, as you genuinely listen to each other. Whether it's issues to do directly with the competition or maybe social issues, something happened in the morning, listen and say, okay, look, it's okay, we are here for this purpose, and you go ahead with that. And then the last one, which is something I'd already mentioned, is just like courtroom awareness. So for instance, and this is a good trick when I'm not speaking, and when we're in a team and maybe I'm the first oralist, I'm done speaking and the second oralist is speaking, then I think usually it's my responsibility to write down the questions that they've been asked, and vice versa. Write them down, because in the heat of the moment, the questions could be coming, maybe 1, 2, 3 questions, and the person who's being asked has no time to quickly scribe, to write down the questions that have been asked. But as the member who's not mooting, just try to note them down. And this becomes incredibly important. And then now at night, maybe when you go into the hotel or wherever, you can reflect on this and say, let's find the answers for this. And you could find that the same question is asked again in another session. But because you already wrote them down and you have tried to find an answer to them, you navigate it with more precision. And very lastly is, this thing we are talking about, nodding, show support during the session. When the session gets heated, even when it's not heated, usually we are looking, even as I'm speaking now, I'm unconsciously looking to Martin to hear him nod and say, okay, you are saying the right points, you are making sense. And that gives me more motivation, more energy to keep going. So if as an oralist, you are just there, you are like a stone, your teammate is mooting, but you're like a stone. They're like, oh my God, I'm messing this up very badly. And they convince themselves, and then they start to mess in the round. But just show support. Even when they're messing, just show support, smile a bit, nod a bit. It really, really helps with the whole process. Thank you so much, Martin.
Yeah, thank you, Sydney. Once again, I think he's pointing out these things and giving very practical examples, because I think we started as mooters, as teammates in this competition, and then ended up being friends. And it's easier also because then you get to understand each other's dynamics. Of course, I know different teams have different ways of doing it, but even if it's for the show, it's useful for you to be in sync and literally be a team. So don't leave some, like I think last year I met a team outside of the courtroom. They're almost fighting physically. Holding each other's collars. And it's not that deep. 12 minutes to go. We'll seek your indulgence to extend by a few minutes, but I think the last thing I'll talk about shouldn't take me more than 10 minutes, and then we'll take your questions, and then we can conclude. And this last aspect will be about post-moot learning and reflection, which is exactly why I'm starting with that point of you not wanting to fight, outside of the courtroom immediately after you have, finished the round. So on this one, it is important, one, to listen to the comments from the judges. I think that is a starting point. So immediately you finish your session, judges will give you comments. And judges are different. The judges who will only focus on the positive element. They will tell you, you did great, in fact, your finals material, nothing to add. But then also the judges who will focus on the negative, and you should understand, because it doesn't mean the judge who focuses on the negative, has failed you. As Sydney has said, some judges might be very harsh on you, but they're impressed by how well you take the pressure, such that they give you higher marks. So in cases where then you have harsh comments from a judge, or what I would say, difficult, or comments that, are points of improvement, then it is important for you to take note of them. Again, usually you might have, contrasting opinions. And this happens a lot, especially where, you have your judge there, you have your coach, for example, you have your teammate. Everyone is giving you so many comments at the same time. So that is also something else you need to deal with, because then you might easily get overwhelmed by the amount of comments you get. So once you get comments from the judges, the best thing to do is to go and debrief with your teammate. So don't leave one session, then storm out, as Yusuf said. One has gone to the hostel, the other one has gone to Cape Town to do shopping, and someone else has gone to drink alcohol. Even if you have other things you want to do, best practice is sit together, even for about 10 minutes, 15 minutes, to debrief on the session, and ask the normal basic questions. What went well? What didn't go well? What could have done could we have done better? What can we do, in the next round to improve this? So amongst some teams don't have coaches. So if you don't have a coach, it's okay. Just between the two of you, discuss and say, okay, and be honest with each other in a way that is productive to the team. So, say, I think here, you made the jurisdiction arguments. Sydney will tell me sometimes I was speaking too much on preliminary issues and forgetting the merits. Yeah. So take that in and say, okay, let me practice so that I spend some less time on preliminary issues and more time on merit. I tell him, the last issue you argued too fast because of time. I think you need to save some more time for that issue. Such don't tell them that you wasted us. You're the reason we will fail. If we don't proceed, it's on you. No, come on. It's never like that. It's never like that. So don't ostracize your teammate or make them feel like a failure. I think the point is to improve each other and add value. And then the other point here is in cases that you have met together and talked about things you can do to improve, do not just leave it there. The other thing about the Moot is also don't just be by yourselves from the preliminary rounds. If you meet opponents, talk to them after the session. Yeah, even if you think they thrashed you. In fact, talk, and people are very willing, by the way. They will give you tips. They would even be gracious sometimes to share a few arguments. Who knows? You might actually end up as a pair in the final. Yeah. So don't just be your group or the group from your country. Sometimes we see the tendency where you're only meeting with the people who you speak the same mother tongue or the same vernacular language with. No. So if you're from Western Africa, please meet people from Southern Africa, from East, meet people from the North. That's the whole idea of the Moot. I think the Moot is less of a competition and more of the network. And this is something I want us to think about a lot. It's less of the competition, more of the network. So yes, we are coming to the competition, but it's to meet, to exchange ideas, to interact, and to make our continent better. Yeah. And I'm sure, in fact, I was telling Sydney, Yusuf, we need to probably start having a registry of the marriages arising out of people meeting from the Moot. We would need to document and see the friendships kept beyond borders.
Trust me, there is a number, an interesting number.
Yeah, but on a light note, I think that's the point of the competition. So I'll leave it there and say that I hope you've learned something from this, and take it all in. I know it's a lot we've discussed in these 2 hours. It's a lot of information, so you can take time to process it. We will be on the ground in Cape Town. Sydney, Yusuf, and I will be there. So we want to be there, and if you have any questions, you can always talk to us. So don't be afraid. This competition is ours, and all of you must come back again next year and the year after with the same kind of pride and commitment to this, because we're creating a network of lawyers on the continent who can support each other and who can support the human rights agenda on the continent. So I'll leave it there, and then Sydney could also conclude so we take some questions. Thank you.
Yeah, I mean, no, like super happy to take questions. Thank you so much for that. I think I don't have anything substantive to add other than to just thank Yusuf for facilitating, and everybody, whether it's faculty or participants, for being here for this long duration, and really happy to hear any questions, comments, anything that's not been clarified, and we would be happy to respond in real time. Yeah, anything really, whether it's a question, whether it's something we mentioned that didn't seem to come out very clearly. Yeah, and we can do that for a few minutes and then call it a day. Yeah, so I think the floor is just open to anybody, really. Yeah. Or maybe as people prepare, Yusuf can say something if there's anything on your side that you'd want to say, maybe.
No, I think you. Yeah, I think you've covered. I don't know. Maybe I saw a question, but I think Martin responded in the chat. So maybe you could, as people, think about the question, maybe just, I think a teamwork during, maybe you can talk a little bit, communication between the two oralists. I mean, how do you communicate? Because there is an instances where, let me say, the first oralist, you realize that maybe he's a little bit, where you can probably quickly, scribble something, pass a note, just maybe you can maybe talk about, the communication between oralists during when the session is underway. I seen Tente. Maybe we listen to this question for the one who just raised, then you can answer them together.
Hi, sir. Am I audible?
Yeah,
Yes,
go
you are.
ahead.
Okay, yes. So firstly, I have one question. So what happens in cases where you get a question from the judge and unfortunately you're not sure of the answer or you don't know the answer? Is there maybe a more of a proper way to say you're reserving the question maybe for the second speaker? Or maybe you believe maybe what the issue they're going to address on would provide answers to the question that you are getting, so that or maybe you just answer the question and risk maybe going over and like putting points that the second speaker would say. And secondly, it's just an appreciation comment of this session. I was having some consideration and some conflicting minds. And now I'm more clear now because of the session of maybe, okay, this was what I'll do, this fits my style and all of that. So thank you for this. It really put me at ease that no man, it's doable and we have it.
Okay, yeah. Sorry. Thank you for the kind words. I think I could take this question and I think the first one on the chat from administrator, and then Sydney could address the one from Pal. So in terms of questions, so when you asked a question whose answer you do not know, or which you are uncertain about, don't just answer the question for the sake of it. I think it is important to appreciate the questions by judges. And as I've said before, judges are deliberate about the questions they ask you. So, and it is okay to admit that the question is tough. In fact, it's a point of humor and it's a truth that these questions are not easy. So if a question is tough and you struggle with it, it's okay to admit, Your Excellency, that's a tough question. Because it's something also that we struggled with when we were preparing for these submissions. Then now, see, that way actually you ease in the mood. They're like, yeah, they don't expect you to have a perfect answer, but at least you attempt. And then now you can just explain what your position is on that matter. Now, in cases where it relates to a point that will be raised by the second speaker or your colleague, so this is assuming you're a first speaker, and then you asked a question that relates to something your colleague will address. There's two things. One, you need to understand and know your colleague's arguments, so that then at a surface level, you're able to give a response and then say that this question will be addressed more substantively in the argument by my colleague. So don't just leave it hanging. I'm not an advocate of throwing your colleague under the bus, because sometimes you could promise that your colleague will respond to 5 questions, and then now judges wonder, then what are you doing? Why don't we listen to your colleague? So I think best practice would be, one, if a question is tough, acknowledge it's tough and explain, give the answer that you have in mind. And then 2, if it relates to an argument to be made by your colleague, first understand all your colleagues' arguments, so that then even on a surface level, you can say that this is our position on that question. However, my colleague will address it substantively as he deals with, say, should be later. I think that usually is sufficient. And then for the question on the chart on ideally how long it is advised for jurisdiction and admissibility to take from our time, look, again, this is you being flexible because you know what is contentious, you know what is important to mention. So you look at your time allocation. As first speaker, for example, if I have an allocation of 15 minutes and I have the admissibility issues and 2 other issues, then I could ask my colleague to give me maybe 3 minutes. So I do 18, for example, because there's more. That's one way. So you have more time. So your colleague lends you, maybe you do 18, they do 12, but I think there's a minimum. So you check whether it's within the rules. And then that way also, so you check 5 minutes here, 8 minutes there, 5 minutes there. So then you can balance. And for example, especially for jurisdiction, because other time questions usually have not a reason. So it's easier to make shorter arguments for this, especially where they're not contentious. So point by point, perhaps even in 2 minutes, you should be done with jurisdiction. And then for admissibility, because it is best practice to go issue by issue. So is issue A admissible? Is B admissible? Is C admissible? Is D admissible? Could take usually a minute or 2 for each of them. So with 4, 7 minutes would be fair. So we shouldn't take more than 8 minutes on both of them, at least from my experience mooting. Because then for each of the issues, at least have 5 minutes to address the issues. 5 minutes, 5 minutes. Yeah. So jurisdiction could take 2 minutes, admissibility 5, 6 minutes. But again, this is depending on how much you intend to argue. But that's what you need to have in mind as a calculation, so that then you're very clear. And also on that point, before I allow Sydney to answer the other question, when you realize your time is running out, please do not be oblivious. Don't assume that you will get more time from nowhere. I think sometimes someone is speaking, the time is up, they continue to speak. No. The moment you realize you have 5 minutes to go and you have a whole issue that is not addressed, conclude on the one you're arguing and begin on the other one. In fact, we should have mentioned that it is not good practice to leave a whole issue not argued. And judges some judges could even penalize you for that. Because like, you didn't make any arguments on issue C. So we don't know whether you agree or not. So do not leave a whole issue unaddressed, because you must be conscious of time. So you realize you have 5 minutes to go. You have a whole 2 issues you have not touched. Please conclude that, touch on the 2. Then the other thing on time is prepare summary arguments for the last issue you're arguing in all cases. So for example, if you're the first speaker and your last argument is issue C, or you are the second speaker and the last argument is issue D, have summary arguments for those. A summary argument that can be made even in a minute, such that where you are so pressed for time and you couldn't escape the questions, and you are given 1 minute to conclude, then you make that 1 minute summary argument. And then lastly, when your time comes to an end, please request for time. Don't assume that the judge will give you 1 minute of additional time, or that if you continue to speak, they will not interrupt you. So when you know you have less than 2 minutes, usually 2 minutes or 1 minute to go, you could say, Your Excellency, Judge President, I see I have a minute to go. May I seek an additional minute to conclude? Most times you'll be granted that. Then use it well. Don't now start to go back to storytelling when you know you have just a minute to go. Yeah. Sydney?
Thanks a lot. Maybe Yusuf can go first.
No, it's a quick time management, but maybe I wanted to address that because I've seen, and you've seen it as, judges and what. These, oralists, end up losing a lot of time. In a situation where you ask a question, they will answer the question, then they wait because they are waiting. They think the judge is going to tell them, okay, proceed. The moment you feel or you think you have answered the question, you don't wait for the, just go. If the judge feels that you did not answer, then he's going to interrupt. He's going to say, no, kind of thing. But I've seen every time it's like, you answer the question, then you're waiting for him, to tell you, move on or whatever. The moment you feel that you have answered, move on quickly. As I think this is the time management they're talking about, you're going to realize, you're going to realize whether you have 18 minutes or whatever, you're going to realize that they fly.
Exactly. Yusuf, you
No, yeah,
disappear.
I'm done. You can proceed. I was just, making a note when it comes to time management and how the advice you should tell them, because all of them, they tend to feel, they tend to think that, okay, until the judges has said that, he or she is satisfied by the answer, I can't move on. Yeah.
Exactly, exactly. That happens a lot. The other aspect where time is usually lost is, where you say, having made or having introduced ourselves, unless there are any further questions from the court, like if the court has no further questions, like please allow me to proceed, something like that. No, 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 no. Just take the agency and say, having introduced ourselves, I will begin with the first issue, which is, and then proceed. So don't have these gaps where you're waiting for the court to give you an okay, because you're waiting and they're waiting, and then 30 seconds get lost. Yeah. In response to the questions on communications, I think just gently writing something down on a note, if you can have the sticky notes, the small ones, or just not like an A4 page, or like you, as Martin mentioned earlier, you have like, I don't know, the memorials printed out and you are scribbling, loudly and all of that, and then you are passing, don't, just if you can do that, just a small piece of paper, just write something, briefly and pass around, and then now the obligation on our side is to do the briefing with the judges so that they allow this. Any passing of notes that is not, that is, inconspicuous, that is not so loud or, crazy or, disrupting the session, should generally be allowed. This is usually allowed in court. But also when you're passing down notes to your team members, remember you can't write a whole paragraph, because when they are making the argument and they have this note, now on their hand, like everything is just mixed up. It's like the question you asked, it's now like you're an Anglophone speaker and it's like everything they wrote is in French. Now you can't understand anything. So just make it short in something that they can understand. Reserving questions to the second counsel, Martin already addressed this substantively. As a rule, unless you're very certain they know the answer to that question, don't do it. Because when you make the promise and it's not met, it doesn't speak well to your teammate. The final question on where there are French names. So here's a trick. Largely speaking, in the preliminary rounds, most of the judges speaking in the Anglophone rounds are Anglophone speakers as well. But it's, it's a dance, it's an art. What I would do, for instance, if I were in your shoes, pal, I would try to practice what the French version, or what the actual French pronunciation is, and come and pronounce it in French. And then, it could be a source of humor, the judge could appreciate. Maybe they would, maybe they would not, but it's not rocket science in that case. Or maybe give the abbreviation if you really, really cannot pronounce it in French. Maybe give the abbreviation, and because it's already abbreviated, then hopefully this does not come up as an issue. Yeah, welcome. Martin, do you want to take this one from Luther?
Yeah,
Okay.
sure. Yeah. So do you think it's ideal for the first person to deal with both jurisdiction and adjudication at the same time? Yeah, ideally, because when you come before the court, it doesn't make procedural sense to begin with the merits. So you say, thank you for the opportunity. We'll begin with issue D. And this is the point Sydney talked about on understanding the procedure of the court. So, so when you go before a court, the first thing you must talk to the court about, before you deal with the issues that have brought you there, is telling the court that you have the competence to hear us, to determine this matter. And that is jurisdiction. And your competence is because of this and this and this. Two, so first of all, the court has jurisdiction. So the court has the authority. You confirm that the court has the authority. If you're responding, perhaps you challenge the court's authority. Then the second thing is tell us now, okay, these issues we are bringing before you are admissible, that they can be heard. So that's the point of procedural issues, that the court has the authority and that the issues can be heard, so that now we hear the issues. And then it wouldn't make sense that a first speaker, for example, deals with jurisdiction and someone else comes to deal with admissibility. It is best practice to handle them in that order and by the first speaker. Yeah. And then on the issue of the French names, just to add, Sydney gave a very good answer. Yeah. The point of the Moot again is to appreciate that on the continent, we have different languages. And even for this session, you saw we had to apologize to the French speaking teams because we couldn't find a translator in good time. And in fact, Sin and I are learning French now because we think it's useful even for this competition. So try to practice how the French words or the Portuguese words are. But again, as Sini said, for most of them is abbreviations, probably, APDH versus Cote d'Ivoire or IHRDA. So they exist in abbreviation, but it will be useful to challenge yourself as Anglophone speakers to learn some of these French terms. Also, because the last thing I'll say, those of you who make it to the final rounds will realize how challenging it is to communicate with French or Portuguese teams, because we live in a continent where sometimes even the French teams do not speak English or the Portuguese teams don't speak English. So you end up paired together in the final rounds with a Portuguese speaking team, and you have to find a way to communicate. Much as you have a translator, a lot is lost in translation. So learning some little French is useful. And if you haven't, it is something that you should also take as a takeaway from this session to consider learning French or Portuguese. Yeah. Thanks. I think that's it from me. And I see we're already 11 minutes past time.
Yeah.
So, yeah.
Yeah, same here. I know both Yusuf and Martin would be amenable to this, that if there's any other questions, you could just write it in the WhatsApp group. All of us will be able to see, and we are happy to respond to you. Or maybe in the past session, I had somebody who texted me like on my inbox, and they were asking a question, and it was specific, and I responded and all of that. And all of us, we are really, really like happy to do that. And thank you so much. Also, Ntetelelo. I hope I didn't butcher your name. It's very, very doable. I think really appreciate that you enjoyed it, and I hope like that's a sentiment that's shared across board. It's very, very doable, especially when you're a first-time mooter. All of this can seem too much. But it's really, really doable. Just trust the process, keep practicing. And when you are there, you'll discover people are very, very friendly. You'll make friends, there'll be people to support you, and as you go through the process. So don't, get struck by lightning at this point. It's going to be a good process for you. Yeah, thank you.
The pronunciation actually was good. But I'm going to take you through it in Cape Town. By the time we finish the Moot, you'd even be knowing my clan names.
You'll discover I'm your brother.
Yeah, thank you.
Welcome. Maybe Martin, we can hand back to Yusuf.
Yeah, thank you. That's it from me, Yusuf. I think you can take it away. Thank you guys for making time, and all the best. We're happy to assist with any questions and look forward to meeting you in Cape Town. Thank you.
All right. Thanks, Sydney and Martin, for availing yourself to do this. This is, I hope it's been, informative, and participant, benefit something out of this. I'm very sure. And thank you for everyone who took time on Saturday, to come, And the other thing, as they were saying, there is a lot of material on the website, particularly the video of the finals, purely oral, oral presentation. That's a trove of information is going to tell you most of the stuff we're talking about, whether it's etiquette, whether it's how you handle pressure, that kind of thing. I think that's very, very critical that you go through, watch those videos, and you see different style, even different, personality when it comes to judges, how they handle, how they behave. But otherwise, thank you very much. As Sine was saying, that we are a WhatsApp away. If there is a specific question, please go ahead and drop us, a text, and we'll be we'll be happy to help with something. Otherwise, we'll be seeing you in Cape Town in about what, 7 days, 8 days. Okay, so safe trip, and see you in the mother city.